So now I'll hand you over to Professor Sarah Green, and we look forward to hearing from her in relation to the road ahead for crypto assets in the UK.
Okay, thank you very much, Deborah. Good afternoon, everybody. The road ahead for crypto assets. It's been an interesting 4 or 5 years. So I know that the title of my section today includes the Digital Assets Bill. So obviously, I'm going to talk a bit about that and its progress. But before I get onto that, it's probably worth my saying a little bit about what else is going on, because to give the impression that the future of crypto assets in the UK is entirely dependent on that bill would be, despite a very recent article in the Times this weekend, would be misleading. So to start there, on Sunday, I'm pretty sure it was this Sunday, the Times referred to the Property, Digital Assets, etc. bill that is currently going through Parliament, which, as I said, I will return to. Gave a brief overview of what that intends to do, and so far so good. Made the point that that bill is basically about establishing the legal point that you can have property rights in digital assets, which is, of course, very good news. But then went on to say, or at least to suggest, no, it was more than suggest. It did say that without that bill, there is no such property right in a digital asset, which is not true, and is actually a pretty damaging thing, I think, to say. And it was quite ill-informed. So I'm quite, as you can probably tell, a little vexed with that bit of reporting. So I just want to make it very clear that actually the future of crypto assets in the UK and their legal status and position is not particularly dependent upon that bill. So you might ask, why on earth bother with it? Which would be a good question, but I do have a pretty good answer to it as well. So what the Law Commission has been doing over the past 4 years is addressing the fundamental question, which I suspect is of strong interest to most people at this forum, which is, of course, how well can you have property rights and digital assets? If so, what's the nature of those rights, and what are the consequences of having those rights? And how does the law approach that? Now, when I started at the Law Commission on this digital assets project in 2020, that was a question that was very, very open. And in fact, the answer to that question, can I have property rights in my digital assets, was by no means clear and by no means certain. And in fact, quite surprising, I think, as a result, to lots of people who had invested or had bought such digital assets, because, of course, particularly if you're not a lawyer, you wouldn't even ask the question, if I spend this amount of money on a digital asset, will it be mine? And will I get the protection in law that I would get, or I do get, when I buy a laptop or a watch or a car? You know, I think we all presume that when we do that, that we will be protected by the law if something happens to that asset or to our ability to control or use that asset. So the question with digital assets was, you know, can that even happen? And why is that? Basically because the law historically was just not used to digital assets as a thing, as a concept. And actually the nature of digital assets meant that they fell between the cracks, really, in two established legal categories. And those categories, I know I haven't got very long, don't worry, I'm not going to give a big law lecture, but I do need to explain this bit. So those two categories historically were deemed to be exhaustive of those things that we could have property rights in, but they're very different categories. So in one category, which are known as things in possession, are all the personal property articles that we would think about, like the ones I've already mentioned: watches, laptops, cars, everything, basically all your property that isn't real property, so isn't your land or your house. And that, if it's conventionally tangible, so if you can possess it, hold it in your hand, pass it on, then that would be what we call, a thing in possession. And then the other category is very, very different to that. It's property, which is very different. And the archetypal thing that goes in that category, in the thing in action category, is a debt. Because we do have property rights and debts, but we can't possess them in the same way. You can't hold a debt, you can't pass it on to somebody else in any physical way. You need a legal process to do that. Whereas with a physical thing like a car, I don't need a legal process. You could factually take it from me without my permission and without my consent. You can't do that with a debt. So there are very different things that need very different legal treatment. So far, so good. And for ages, that was fine. And we were all happy with it. And then digital assets came along, and it was by no means clear which of those categories, if either of those categories, they fitted into. And so, to cut a very long story short, I'm just checking the time, the Law Commission recommendations was that actually it would be a lot clearer if we didn't try and force digital assets into either of those two categories. And we started with a fresh category, a third category, which was tailor-made, basically. So legally tailor-made for digital assets, because they're not quite things in possession, because you can't. I mean, the biggest distinction, I think, between digital assets and things in possession is transfer. So obviously, if I hand my watch to Deborah, she gets my watch, I lose it. But what she gets is exactly the same thing as left my hand. Whereas, of course, if I transfer a digital asset to her, she doesn't necessarily, depending on the digital asset, she doesn't necessarily get the same digital asset. It might be a process of extinction and creation. So something is extinguished from my wallet and created in hers. And so that's a bit different to things in possession. But they also don't belong in things in action either, because they have an independent existence in the world that doesn't depend on legal recognition. So a debt only exists as long as the legal system recognises it. It doesn't have an independent existence of persons and the legal system, whereas digital assets, of course, do. They do exist, whether or not a legal system recognises them or whether anyone lays claim to them. So that was the Law Commission recommendation, that we have this third category. And basically, it's to stop the common law saying, well, these digital assets, they're not a thing in action, they're not a thing in possession. Historically, that has exhausted personal property rights. So we can't have property rights in those things. That would be very problematic, incredibly problematic, because it would mean that those assets don't get the protection of the law. So the Digital Assets Bill is a very short bill. It is one substantive clause, and it basically says a thing is not prevented from being the object of personal property rights simply because it's neither a thing in action nor a thing in possession. Now, that's very short, obviously, and there have been some objections levelled against it being that short, but it was very deliberately that short, because the idea is that case law then builds upon that, and the case law works out the detail, which is a far, far better way for the law to develop. Because if you try and put in statute particular technology or a particular type of digital asset, then that statute is going to be obsolete in a number of years. So where are we with that bill? I'm conscious I've only got a couple more minutes, so I'm nearly there. That bill, Law Commission Special Procedure, which means it's quicker, it's an expedited process. Which means it starts off in the Lords and it gets most of its scrutiny in the Lords because it's non-controversial in a political sense. So it doesn't need to go through all the sort of House of Commons fighting that can happen, I suppose is the best way to put it. It gets a very sort of deep intellectual analysis in the House of Lords, and that's been done now. So we are just waiting to see where that comes out. I'm very hopeful that it will pass, but of course I can make no guarantees. The parliamentary process is to some extent a bit of a black box. Even though I've done it 4 times now, it's still not that apparent to me. It needs to go to the House of Commons, but as I said, most of the debate has now happened. The last thing I will say, which is to bring it back to how I started this section, is that actually I don't think it matters too much. This bill will be excellent if it passes in terms of its significance, its symbolism to the rest of the world, that as a jurisdiction, we take digital assets and their property rights very seriously. And it will be very helpful for judges. In fact, it was judges who asked for it. it will be helpful for them as a base from which they can develop the common law, so judge-made law. As I said, they specifically requested this. So it will be very helpful, but despite that report in the Times and some other reporting that I've seen, it isn't absolutely necessary for property rights in digital assets to exist and to develop. And in fact, since 2020, we've had quite a few case law examples, examples of litigation where this point has been tested, and it is now pretty much recognised by the common law that you do have property rights in digital assets. So the detail needs to be worked out, and as I said, this bill will be fantastic, I think, certainly in terms of the notice that it sends out, but it's not absolutely necessary. So in short, the future of digital assets in the UK, I think, is a very rosy one.
Thank you very much, Sarah. Excellent summary in a very short space of time. Thank you so much.